for change in the way in which legal services are delivered. Sure enough, in England and Wales, the Legal Services Act is the first exponent in these islands of this kind of change in the way in which solicitors can relate to other professionals and deliver services. And certainly in Australia there have been changes, but changes are afoot in Europe as well, and we can't forget what's happening in Europe. An earlier question related back to the Clancy review in 2006-2007, but before that, Commissioner Monti had embarked upon a European Commission-sponsored review of legal profession in Europe, and he found that there were a number of restrictions, and that has resulted in a relaxation of restrictions in countries such as France and Germany, in Italy, and it's quite clear that some of these countries, taking it to be understood that you can't really just compare the legal profession in France with the legal profession in Scotland. There are inherent differences, but it is possible in France for certain arrangements to be made in terms of what they call société interdisciplinaire. In Germany, under the Bundesrechtsanwaltsordnung, there are capabilities for solicitors or lawyers to enter into relationships with accountants, with tax accountants, with patent agents and others. In France, the Règlement Intérieur National allows for similar changes. And in Italy, they removed all the restrictions in certain forms of relationship between lawyers. So I think we tend to think of Europe as being fortress Europe, and that there is no change happening there, but that's not entirely true. And in terms of external ownership, in Spain, as I understand it, and also in some of the Nordic countries, external ownership is now permitted.
Okay, thank you for that. But again, one of the written submissions that we've had as a committee suggests that that this piece of legislation is a threat to Scots law, and it will lead to its marginalisation. It's going to allow people from outside Scotland to come in and work with this system that's alien to them. And the legislation in England, according to this evidence to the committee, does not threaten English law. The difference is here that this threatens Scottish law. What would you say to that?
For us, obviously, the separate system of Scots law is a matter of absolutely critical importance. But we do now have cross-border firms operating. We think, ironically enough, that this legislation is exactly the other way around. That the danger is that if there is a liberalised legal services market in England and a restricted legal services market in Scotland, but with the opportunity of the liberalised sector operating in Scotland, and that's what the current legal position is, actually that is what imperils the independence of the Scottish legal profession, that the big commercial firms up here will choose to be regulated in England and Wales, but will still continue to practice in Scotland. We have, perfectly amicably, already some of the bigger English firms already have branch operations up here, but the Scottish end is, at the moment, is very much the smaller end of it. But we do have a situation where a lot of our big firms have a London base where they could choose to jump their switch, their regulation, to choose a in vogue phrase, to be regulated in England and Wales. And that actually would be much, much more of a danger to the independence of the Scottish legal profession. That no change is much more of a danger to the independence of the Scottish legal profession than change would be.
Okay, so you totally disagree with that?
It's fundamentally disagree with that.
If we talk about the preservation of Scots law, this institution in which we're sitting is one of the foremost bulwarks against Scots law being denigrated or becoming an item of the history books. So, I think we've got to stand back and look at this realistically. 10 years ago, the Parliament came into being in order to give Scots law a rejuvenation, and it has done that. and we've got to be proud about that achievement rather than sound the toll bells for the funeral of Scots law. Legislation which is permissive may in fact give Scots law an opportunity to shine across the world, to provide access to justice to a lot more people than those that we currently serve.
Yeah, that's exactly why we must take very seriously the written submissions that we have and put them to expert panels when we have them available. If I could move on now, Convener, to still within the outside ownership, but going now to the investment. Now, Mr Smart spoke about outlining some of the situations we're in just now where people have had money that's not from squeaky clean sources perhaps, but there's a concern that the committee have that perhaps this legislation in the bill as it's written is not strong enough in making sure that it prevents people, third parties, from investing in a law firm when they might have a checkered past. And I know earlier on, Mr Smart, you referred to section 50 and 51. I think you'd said that if these two sections were not in the bill, then you would not be able to support it. Do you think 50 and 51 properly cover any practice that would take money from an outside source?
Again, although the question is asked to be, I'll defer to the experts in this, either Michael or Katie, to answer this, if that's all right.
I would defer to the experts too, but I'll try my best to answer. You'll just have to put up with me. Section 50 sets the test for fitness to own, and you have to read Section 50 quite closely to work it through, but by and large, operates on the basis that an outside investor has to be a fit and proper person. Their financial affairs have to be in order. They have to be of good character and of probity, including their associations. And they have to fulfil certain types of conditions. Now, the conditions are, I think, examples of what might be thought to be things which would count you out for being an outside investor. So if you're bankrupt or sequestrated or something like that. But your question concerns criminal activities.
Not just, we're all aware of the anecdotal evidence that's out there that perhaps tanning parlours, car washes, these businesses are used perhaps to channel money through. And the committee has a concern that if we don't get this right, that there could be a way, perhaps the next big thing would be a solicitor's firm to channel your money through.
That's why the bill makes provision that someone cannot be an outside investor if they have committed an offence of dishonesty or been sentenced to a period of imprisonment of 2 years or more, or given a fine for any offence. So these provisions are there, and behaving properly in Section 51 includes soliciting unlawful or unethical conduct. So I think that the bill, so far as it goes, answers some of those points, but the real issues which we can talk around the margins of whether an offence of dishonesty could be embellished so that it includes an offence of serious violence or something like that. We could talk about whether level 3 in the standard scale is appropriate, should be level 2, is it 2 years imprisonment rather than 1? These would all tighten those provisions. But I think when one looks at Section 39, part of the key issue is that the head of legal services, as I mentioned before, has to be a solicitor. The head of legal services is given duties under Section 39(7) to make sure that the practice has fulfilled its duties under the bill and under any other enactment. And if there's a failure to fulfil those duties, the head of practice gets involved and has to report such a failure to the approved regulator. Now, any other enactment